Hi, everyone. My name is Smitha Menon. I'm from Wong Partnership in Singapore. The Singapore courts have a strong policy of minimal curial intervention, but that doesn't mean they're not in charge. Even in the last 2 decades, approximately only 20% of award challenges have succeeded. The courts have made it very clear that if there is a breach of natural justice or an exercise of by the tribunal of an excess of jurisdiction, the court will not hesitate to set aside an award. One such case is that of CAJ and CAI, which is an arbitration that arose from the delayed completion of a construction project. The tribunal allowed the respondent to mount an extension of time defense that had not been pleaded, was not in the parties' list of issues, and not in the terms of reference for the arbitration. In fact, this extension of time defense was raised for the first time after the hearing. It was in the parties' post-hearing briefs. Now, the tribunal accepted it and awarded liquidated damages for 74 days of the delay instead of 99 days. The court felt that this ruling was made in excess of its jurisdiction, the tribunal's jurisdiction, as well as in breach of natural justice, and took the view that it was appropriate for the part of the award pertaining to the extension of time defense to be set aside, and for the rest of the award to stand, such that the claimant would be awarded the full extent of liquidated damages, i.e. for the full 99 days. Now, the reason why the court said that the extension of time defense was outside the arbitration scope was because it hadn't been pleaded, it wasn't in the terms of reference or the list of issues, and it couldn't be read into any of the existing pleaded defenses, nor could it be regarded as a natural consequence flowing from or shoehorned into the pleaded defenses. In fact, the extension of time defense hinged on a contractual provision that was subject to specific express conditions. So invoking such a defense was fact-sensitive, all the more needed to be pleaded. The court also felt that this was a classic case of a breach of natural justice. First, the claimant had no notice that it needed to address the extension of time defense until the closing submissions, and so had no opportunity to respond, or no reasonable opportunity to respond. Separately, the tribunal had relied on its own experience with extension of time claims in other cases to adjudicate the extension of time defense. It didn't rely on any of the evidence that had been adduced in the proceedings. The court felt that this meant the parties had no opportunity to address what the court called the tribunal's unarticulated experience, and this alone was a further breach of natural justice. So what is the appropriate recourse? And this touches on who is in charge, the court or the tribunal. The court decided there was no reason to remit the award. Even if there was no excess of jurisdiction, there was still the finding that the tribunal had acted in breach of natural justice, and this was a separate ground for setting aside the award. But had the successful challenge been limited to one of natural justice, the court would still not have remitted the award, as the court also said that the only way for the tribunal to properly adjudicate the extension of time defense would have been if an application to amend the defense had first been made and the tribunal had invited parties to submit on whether to allow the amendment and then consider whether to permit fresh evidence. All this would have been manifestly unfair to the claimant at this late stage. So what's the main takeaway? This case affirms the importance of clearly articulating all the issues that are to be placed before and determined by a tribunal that is seated in Singapore, because the jurisdiction of that tribunal will be limited to what is set out in the pleadings or some other document that encapsulates the issues to be determined. Thank you.